Okay. Sorry.
Okay.
Suddenly, I have second thought about the whole recording issue.
Leo,
We're gonna take a
Huh?
picture of it in the
Isn't
house
that
and then we'll show you.
Which part?
cool?
No, that
I'm
part,
sure
no.
we're not selling it off.
Well, no, not yet. We have to, you know.
And even though
Wait.
you wouldn't.
Great, so now,
Of
now
course.
everyone knows about it.
Can you do it?
Thank you. That's my father's gift.
Thank you. I'll teach Sheila. It's a girl thing.
It's a girl thing. I said it's my father thing, but yeah.
Your mother can get away with everything in my books, even girl things like whistling.
Okay. Hi. No round of introduction is needed this time. Unless Sophia wants to introduce herself.
I would like to introduce Ido, who is a director of the center and has organized this magnificent event along with Michal Bengal, the research coordinator.
Just gave me the status of Ellie Salzberger, but okay.
I was a professor, don't worry.
Okay. First of all, thank you for the invitation.
This is really good.
You're welcome. You're very welcome.
Thank you.
It's hard to get through here.
This presentation is based on a policy paper I published at the Israel Democracy Institute a couple of years ago. And the notion behind it is the legality of undercover units as units that are dressed up as civilians and operate usually outside the border of the state. And the test case of the policy paper is actually the Israeli Mistarvim forces, which Mistarvim is a play with the name of Hebrew of dressed as Arabs in a way. And the question of the policy paper is basically the legality of the use of undercover units under international law and especially under IHL, where there is a unique status, unique complicity of the fact that Israel undercover units are actually operating in occupied territories. And let's see how we go with the time and see if we can make it to the specific test case of the Israeli forces. If not, Manu, it's for the Q&A.
What was the question?
Exactly. So the use of undercover units is not something new. It's not something unique to the Israeli concept. We can see, we can track use of undercover units to the Second World War and even before that. It continues throughout the years, and it's definitely a well-known practice within armed forces. Such operations of undercover may operate as under law enforcement by policemen. It can be operated by combatants as part of military operations, and it could be used for espionage to gather information. It can be used to destruction of property like bridges or facilities, and it can be used to either kidnap or detain a person, or to the vast extreme of that scenario, to assassinate someone or to target killing someone, or basically to kill or wound a person. Despite the fact that the practice is quite frequent and common, there hasn't been much of discussion about its legality, the legality of the use of undercover units. There has been some writing about this issue, but not sufficient discussion. There has been scholars who wrote about it, and which I used and related in my research. However, I found that a complete analysis of the origin and the discussion and outcomes hasn't been done, and it's the policy paper that was done. This policy paper and my presentation, my research were focused on on the use of undercover units by regular armed forces, meaning soldiers of states and not non-state armed groups, guerrilla warfare, etc. So when we identify the use of undercover units, this is the framework I'm relating to. So let's start with a simple but yet complicated example. In November 2015, IDF soldiers dressed up as a pregnant woman and staff went into the West Bank to detain a wanted person. That wanted person was in a hospital in the West Bank, in Area A, and there was a need to detain him. They went into the hospital. They managed to detain him, gather him, and bring him back to detention safely. However, in the same room that he was held was his cousin, who might or might not was there to protect him, and that cousin was killed throughout the operation. So we have an undercover operation to capture a person, which end up with someone getting killed, but not necessarily the person that the operation was to detain. So hopefully this will be the example which I will eventually use when I analyze the situation. One thing I did forget to mention, and credit is where credit is due, the paper was written under the supervision of Professor Yuval Shani at the Democracy Institute, and that should be included as well. So the main questions related to the use of undercover units under international humanitarian law, especially, are first of all the question of distinction, because when you're operating undercover, you're not wearing uniform, you don't distinct yourself. Actually, you're doing the complete opposite. You're dressed up as the locals, you're dressed up as the civilians. The legal framework of the activity, are we talking about risks of war, treachery, perfidy, espionage, law enforcement, whatever, what are we talking about here? And the outcome of such activity, could be the loss of POW status, the requirement to do investigation in case of kill or wound, compensation, and other examples. So let's start with the principle of distinction. The principle of distinction is by far the fundamental principle of international humanitarian law. It is commonly acceptable that there is a requirement from armed forces to wear distinctive signs, emblems, and usually uniforms in order to gain and maintain their combatancy status and combatant immunity that comes with it. Now, the principle of distinction has two elements. One element is a negative aspect to refrain from attacking civilians, to do everything you can to refrain from attacking directly civilian population or civilian facilities. And conduct your attacks only against military objects and military targets and other combatants. The positive aspect of distinction requires the parties to the conflict to take measures to distinguish between their own combatants and military objects and the civilian population and civilian objects. However, despite the fact that we have the positive and negative aspects of distinction, after looking at the sources of the Geneva Conventions and additional protocols, commentaries, and other writings related to that, I could not find any positive obligation to wear uniforms from combatants at every part of the operation. Now, Article 4 of the Third Geneva Convention, which talks about POW status, could lead us to the loss of combatants' privileges, not necessarily the status of a combatant. Article 44.3 of the Additional Protocol 1 talks about when are you supposed to wear a uniform and be distinguish yourself from the civilian population during an attack, and we're gonna get to it. Now, acting undercover can be related to, in a way, three elements of operation. One is gathering of information. We're talking basically about espionage, gathering information, going undercover, trying to be combatant James Bond, I would say, operating as a civilian, just to gather information. Although James Bond do other things as well. So gathering information. The second one is legal armed activity. Legal armed activity that is in conformity with international law. So if you're gonna lose your combatant immunity, you might be indicted if you get caught for such activity, and IHL violations. So if you do violations of IHL and you get caught, well, in this case, you're liable regardless of whether or not you're a combatant or not a combatant. However, there are IHL violations in which wearing uniform is an essential element of that violation. And this is where we talk about treachery and perfidy. Now, treachery and perfidy are meant are violations, prohibitions that are meant to prevent you from violating the trust of the adversary for the purpose of killing, wounding, or capturing that person. Now, such breachment of confidence can include the use of a white flag, the surrender flag, pretending to be an injured, pretending to be a sick person, pretending to be a civilian that is not involved in the activity, in the hostilities. Now, the common element of these prohibitions is that any use of these elements, the use of white flag or pretending to be an injured or a civilian, would harm the very basis idea of protections within international humanitarian law. If we're going to use white flag to disguise an attack, no one's going to trust white flag anymore. If we're going to pretend to be wounded persons and then attack, no one's going to lay off wounded person, which is the essence of international humanitarian law. Allow attack, but also protect the ones who are or the combat or civilians or medical staff, etc. So the outcome of that would be an increase of risk to the ones we actually want to live out of the cycle of hostilities, or at least to prevent or minimize the damage to them. Now, throughout the research, I found three rationales that stand behind this kind of prohibition on treachery and perfidy. The one is the notion of distinction, which I just discussed. The second one is the principle of chivalry. I hope I'm saying that word correctly, which is a basic principle stands behind a lot of international humanitarian law, and it provides some kind of code of honor between combatants. And if you talk to combatants, you talk to combatants, or the frontline combatants, the one who are actually doing the fighting, unlike the regular wide definition of combatants that we have, they have a lot of pride about the fact that they don't only just fight, but they fight in honorable way, in the right way. And although it doesn't exist in the rules, it definitely has been there from the beginning, the note of chivalry, and still remains today. The notion of the fair fight still exists within combatancy, where it should be noted that this principle of chivalry doesn't prohibit on the use of other measures like ambush or sniper shoot from a distance. Last, the third rationale is the notion of reciprocity. Again, although today there is no reciprocity in international humanitarian law, that basis of reciprocity lies behind a lot of the basic of international humanitarian law, which means I'm not going to attack your civilians, you're not going to attack my civilians, I'm going to respect your wounded person, you're going to protect my wounded person, etc. Now, in order to identify when treachery or perfidy are taking place, and I'm saying treachery and perfidy as equivalent terms, although I do believe and argue that there are separations between them, and this differentiation is important, if not crucial, to the application to undercover units. Now, the first element of treachery is the invitation of the confidence of the adversary. If I don't invite that confidence, there is no need, there's nothing to violate. The second one is the existence of protection afforded by international law applicable to armed conflict. And the third one is the intent to betray that confidence provided by the protection in order to cause a relevant end result, either kill, wound, or capture. Thank you. Now, all of the three elements must be fulfilled in order for a treachery or perfidy violations to take place. Now, if it's not perfidy or treachery, it doesn't mean that the operation has to be legal. There are different violations that could be breached. However, none of the other violations is necessarily related directly to the use of undercover units. So let's move forward with that. One of the clear objectives of using undercover units is to get into the territory of the adversary without being discussed, without being detected. Yeah. So we want to maintain that element of surprise, otherwise there is no point of the whole notion of the use of undercover units. And clearly practice showed that there is use of undercover units, and if we completely prohibit the use of undercover units, we're just going to make the law impractical, and the law has to maintain that balance. So under what circumstances undercover activity constitute treachery or perfidy? So the idea is that I want to deploy my forces without being discovered. When I saw that element, that was the point that I managed to get forward in the research, because it reminded me a lot of Article 44.3 of the Additional Protocol 1, which discussed about the fact that the guerrilla force is required to carry arms openly during each military engagement and during such times as he is visible to the adversary while he is engaged in a military deployment preceding the launching of an attack in which he is to participate. This is the no. But I'm using the notion in order to understand the connection between deployment to the prohibition of perfidy, and that same article goes forward and say, an act which complies with the requirements of this paragraph shall not be considered as perfidious within Additional Protocol 1. And that's the connection I was looking for. Now, although Article 44.3 refers to the conduct of non-state forces, the general principle can be attributed, with the relevant changes, to the deployment of deployment question of perfidy by combatants just as well. So the main question becomes, what is the point of visibility? Because Article 44.3 said that during such time it is visible to the adversary. So if we do the same correlation to perfidy, then a combatant can advance undercover until the point of visibility. Now, the commentary acknowledges with regard to 44.3 that the question of deployment and the timing and everything is there is no consensus about it. There has been a lot of discussions about when they should be visible and under what circumstances and under which methods. Now, the principal times of the principal approaches to these questions are: one, any movement from leaving at the base or something like that, and the second one is during the final movement of the attack, basically saying hi. Yes, you saw me? Good. Now, these two questions are weren't easy and were discussed a lot by the throughout the negotiations. And it seems that the more commonly agreed approach was the one that says that from the point of deployment of the forces, from step one. Now, I don't agree that I agree that this is not customary. However, I do think that we could do the relevant correlation to the notion of perfidy. What's more interesting is to see that the discussion about Article 44.3 was regarded to non-state actors with guerrilla warfare usually, and therefore most states argue that from point one. However, if you're going to ask the same states that operate combatants undercover, they want to delay that to the last moment possible because they want to allow their forces to enter as far as they can. So taking both of these approaches into account, I think about three alternatives with regard to the point of visibility. One is once the undercover units are actually moving. So step one from the military base or point of deployment. The second one, once the undercover units are visible or can be visible to the members of the adversary. And the third one, once the undercover units are about to attack. Basically, hi. Now, if we take only humanitarian considerations into account, then first step is the answer. However, as a very smart person sitting on my right said about 3 or 4 months ago, when you're talking about only humanitarian, you step out of discussion of the balance in international humanitarian law between humanitarian and military either practice or necessity, which is required under international humanitarian law. Remember saying that?
No,
right?
I don't, but
Okay.
it makes sense.
So there has to be some kind of balance. And the balance can't be at the point of origin, and the balance cannot be at the height. It has to be at, in my view, at the visible deployment point, the point where you are visible or can be visible to the adversary. And then the question is, what do you mean visible or can be visible? Are we talking about the use of satellites? Are we talking about the use of the naked eye? Are we talking about the use of night vision equipment? Which way are we visible or can be visible to the adversary? What do you know about what kind of equipment does the adversary hold when we're talking about visibility, point of visibility? So my answer to that is the most common legal answer to questions that we don't have answers to.
It depends.
Case by case. If you're fighting against very low tech adversary, then you can move until basically up to almost the naked eye. I don't think that exists that much anymore, but if that adversary has accessibility to more advanced, and you know that they have accessibility to more advanced technological means, then you have to take that into account. Now, going back to the negotiations of Article 44.3 and the differentiation between the fact that then states want to prevent guerrilla warfare to go undercover anywhere, any step other than the first step of deployment, and state went the other way around. I think it's very interesting to note that during those negotiations, one of the representatives was a representative of the PLO. His position on that was only by the naked eye. So only when you're visible by the naked eye and you're that close to the attack, only then you have to show yourself. Only then you have to distinguish yourself from the civilian population. Yeah. Okay. So that's my point of view on when and at what point of time and what means. At this time, I want to make the differentiation that I referred to earlier between perfidy and treachery. Perfidy is from Article 37 of Addition Protocol 1, which prohibits on the perfidious wanton killing or capturing of an adversary while treachery appears in Article 23 of the Hague Regulations and talk about a prohibition to resort to treacherous means for the purpose of killing or wounding an adversary. So killing or wounding under the treachery, and killing, wounding, or capturing under Additional Protocol 1 under perfidy. So the main difference between them is the notion of capture. I couldn't find why. I searched and searched and searched. I couldn't find why there is a difference on capturing. Why capturing was added. And then again, if you look forward, there are two main interesting issues. One, when it became decided to codify international criminal law and put it war crimes, they resorted back to the Hague Regulation, to treachery. They left out perfidy. They left out capture. Only kill or wound was included. On the other hand, Rule 65 of the customary international humanitarian law study argued that its customary prohibition, the perfidy, which is the capture, is only also under that prohibition. Now, personally, when I started looking at the sources they related on a lot on military manuals of states party to Additional Protocol 1. However, military manuals of state related, which are not signed to Additional Protocol 1, actually go to the treachery definition and not the perfidy, which means that I pretty much disagree with the notion that the prohibition on capture is part of customary law. And therefore, there is a difference between operation of states that are party to Additional Protocol 1 and that are ones that are not party to Additional Protocol 1, which means that if you are not party to Additional Protocol 1, like Israel and the US, there is no customary prohibition on you to avoid from capturing while using undercover units. Anyway, even if you do, it's clearly not international criminal law. It's not a war crime under international criminal law because it doesn't appear at the Rome Statute, and it also doesn't appear under any grave breach provision in the additional protocols or the additional conventions to include that. Another question is about the customary nature of treachery, and there I do think there is a customary prohibition on treachery, which can relate also to non-international conflicts, and therefore the prohibition on killing or wounding while resorting to treachery measures, such as undercover units, is applicable to non-international conflict, and this is supported by, from the Tadic ruling, the customary study, which part of it I would agree about the treachery applicability to non-international conflict. There is the Libra Code, which was applicable somehow to the non-international conflict just as well, and so also by scholars like Dinstein, Schmidt, Galway, which we all like and support. So I try to differentiate between types of operations of undercover units. The first one is to gather information. This is completely under espionage, and therefore, if you get caught in accordance to IHL, you lose your privileges, but if you manage to go back to base undetected, you won't be able to be indicted or prosecuted for the espionage you've done. Another type of operation is a type of operation that actually involved violence. So here we have also two types. One, violence against property or other facilities such as bridges, arsenals, etc. This is not under perfidy or treachery. And actually there is no prohibition on doing such. It's considered as a sabotage and there are no prohibitions on that. The second one is operation actually against persons, capturing, with wounding or killing. And here again, I differentiate between capturing, which is prohibited for those who are party to Additional Protocol 1, and not on those who are not party to Additional Protocol 1, and killing and wounding, which is prohibited to everyone at all times. So the outcomes, the implications of operating as an undercover combatant is, for one, you might lose your POW status. You don't have to lose your POW status. It's the discretion of the capturing force. You don't lose your combatant status. You are still entitled to receive and be held with other POWs. You just lose your privileges as a prisoner of war. Article 85 of the Geneva Convention actually says that even if you violated a POW is being tried for violations of international humanitarian law, is still going to be held in the same facilities under the same conditions. So practically you don't lose your POW status, you don't lose your combatant status, you lose your immunity and privileges on acts conducted during conflict. The second implication is that I believe that whenever there is an undercover operation which ended up with someone being killed or wounded, even if prima facie that was a detention or espionage operation, there has to be some kind of investigation or inquiry of how things turn out, and to make sure that there was no treachery or perfidy taking place at the time. And with regard to liability, the question is, if we have a breach of international humanitarian law, and then the state has to be liable for any violations, even if the combatants are not responsible for any criminal liability, state responsibility for wrongful acts might be applicable to the situation. So I would argue that it is legal to gather information undercover. It is legal to destroy facilities and objects. It is completely prohibited to target a person, to kill a person intentionally. And I think that undercover units should come over cover, become identified when they are visible to the adversary. Otherwise, they are getting into the risk of operating in a treachery measures. That's it for now. Please, David.
Okay, Ido, that is very interesting. I have a number of questions. At the very beginning, you said it may make a difference whether you're talking about law enforcement or fighting. Now that becomes extremely relevant in the occupied territory.
I thought this is Manu's question.
Sorry?
That was Manu's question.
Yeah. So, I mean, when the army is
operating, say, in law enforcement in the occupied territories, it's going to arrest a person. Is there any duty for them in the uniform in the first place? When it's not fighting, okay? That is my question. The second question goes back to Sophia and the debate that we had today. What happens? I'll tell you why. What happens and this is actually what happens with the Israeli undercover units, by using undercover units, you're endangering the lives of civilians, not by what you're going to do, but by the reaction of others, because they know Palestinians know that there's a danger that the people suddenly in a demonstration of that may be undercover people, and so they may be freer with the use of force, and you're endangering the lives of civilians. Consideration.
That was for you or for Sophia, the second one?
No, it was for you, but it's because of the duty to protect.
Okay. The first one, law enforcement versus military activity. This is the specific situation of the occupied territories because of the obligation of the occupying power to maintain law and order in the place, and they're operating just as law enforcement and military activity. And we can talk about three types of operation. One is pure law enforcement, and we can see that. I think that we can see that examples by the mere fact that I think one of my favorite examples of law enforcement, regardless of the units, is the fact that I think this is the only place that the IDF is actually using tear gas in order to against demonstrations, which is illegal under IHL. So you can see that shift between the paradigms of law enforcement versus military activity. So as I said at the beginning, under law enforcement, policemen are allowed to use undercover units, and we can see examples. We can actually see that under some resolutions or decisions by the UN, they're actually promoting the use of undercover police work against drugs operations and drugs. I'm using the words. The ones actually manufacturing the big bad guys. They have a name. Drug lords and unit and gangs and stuff like that. Drug dealers. So under law enforcement, we see a lot. I mean, we see a lot of detectives that operate under civilians that hire on a regular basis, and they only have to identify themselves when they are actually doing an operation to arrest someone or trying to use some sort of more active or try to detain someone or actually engage with someone.
When they engage with someone, no. When they arrest someone, the person will say, "Who the hell are you?" So, but if they're acting to use force, why do they have to? Well, if it's absolute, it has to be
I'm
absolute.
talking about the policeman. When the policeman is using force, usually it's common. I know that under the American law, they actually have to identify themselves, and you won't break into a house without
Not breaking into a house, but you see someone there about to place a bomb. You can use force.
Yeah, you can use force as last resort. And
It's absolutely
if absolutely necessary, as a last resort, the policeman is absolutely allowed to use force, even if undercover. I think when IDF is operating in the West Bank undercover as law enforcement, they are not under the prohibitions of treachery or perfidy, and they are allowed to make detentions under law enforcement. And this is where I actually go back to the ambulance example. The ambulance example, there is a really strict question of when do you identify whether it is a law enforcement or a combat operation, and we have some jurisprudence on that with regard to tort law, but not with regard to criminal law. So we have some jurisprudence from the a lot of the district court, but some from the Supreme Court of Israel. It says that you have to look at all of the elements and the nature of the operation in order to identify whether or not this is a combat operation or a law enforcement operation. In the vast majority of cases, the court will conclude that it was a law enforcement. It was a law enforcement operation, and when someone actually got killed, they are making the shift and say, well, there was escalation. It was an escalation, and the law enforcement operation actually shifted to a combat operation.
No, but the nature of the operation cannot change just by the degree of force used. That's not right. It's got to relate to what you're doing.
I agree, but this is not the jurisprudence, not necessarily the jurisprudence of the Supreme Court. And this, and remember, here we are talking about tort law. In the compensation that the state has to pay if they have immunity from combat action. they don't have immunity from negligence in law enforcement, and therefore the common outcome is that the court concludes that because of the disagreement and escalation of the ones they were trying to detain, and we have a lot of these kind of instances where the IDF soldiers approached someone, and once they were identified as IDF soldiers, the other ones tried to either shoot them, and etc. And the ruling is that the situation escalated to a law enforcement. I don't say to a combat activity. I don't necessarily agree with it, but this is the common jurisprudence. Now,
Sorry,
saying that,
am I sharing?
No.
Barbara,
Wait,
have a two
haven't
finger
finished.
on that.
I haven't finished my answer on that. Even if we're talking about combat activity, Israel is still not party to Additional Protocol 1. So capturing, if it's not customary, Israel is allowed to also do capturing using IDF forces undercover. So regardless of how you look at the operation,
But depending on what the default rule is.
well, default will common activity or law enforcement. It's a question of only once it is an operation for detain, the outcome remains the same, and the only the applicable law is changing, because I'm saying that there is no prohibition of detention, and under customary law, because Israel is not part of Protocol 1, and there is no prohibition on detention undercover under law enforcement. So the real prohibition is when they are actually going to either wound or kill someone. This is a complete prohibition.
Can Barbara come in?
Yeah, can I ask two lay questions at the danger that they might strike as completely stupid? One, if in any given circumstance you're not identified as a soldier and you're present in a situation that escalates, are you not, by duty of your mere presence in a jurisdiction, bound to inhibit the crime if you see it happening? Do you not just have to do something to prevent it? So basically, if you attack me, I'm allowed to basically kill you in self-defense if it is in order to protect my own life, in which case it doesn't matter whether I'm there as a soldier, as a spy, or as a civilian person. So obviously it's covered by a different legal regime, but my impression is that it is covered by a legal regime. So even if it's not covered by IHL in this case, there is something that's governing it. And the second point is, if there is a prohibition to become active in the scenarios that you have identified without identifying yourself as a soldier, that might well be the case. But the thing is, you don't plan these operations unless you deem them necessary. So what are the implications? Is anybody going to change their behavior according to the fact that they now know it's illegal? I don't think so. I think if you're planning an undercover military operation, you're doing it for very good reasons. You're not going in there, full-blown flags and everything, because you actually think that is going to pose a risk to your completion of the mission.
It's not addressed to me, so I'm not going to answer.
So maybe that goes too late, but I'm just wondering, what does it mean in the end? Is anybody going to change their behavior?
To comply with the law?
First part. First part is about the distinction. The obligation to distinction is that, first of all, you don't have any positive obligation to distinguish yourself, but even with the stricter interpretation of when do you have to distinguish yourself and wear uniform, it's still not absolute. If I'm gonna basically sit down even in my military base as a combatant, and there is an attack against the bases, no one is expecting me to go dress up, change everything, and then only respond. I can respond on spot. It's okay, it's legitimate, and I will not lose any immunity, I will not lose any privileges. I have to respond at the moment. However, if I do have the
opportunity, and this is why we jump into the second question. If I have the ability to distinguish myself, then practically, when these units are being deployed, they do wear on themselves some kind, they hold on themselves or wear on themselves some kind of distinguished ability. And you can look at it from the legal perspective, but you can also look at it from the practical perspective, because you want to identify your comrade. You want to be able to know that, yeah, I can see that this is one of my units and not someone, an adversary. So if you're going to distinguish yourself in a common way, you're going to be able to do it, even within the fog of war, which might make it a bit harder to respond. So usually practice shows that they do identify themselves when the situation escalates. It's not about changing the metaphor, changing the practice. It's actually the practice shows that at some point they do identify themselves.
But if the situation escalates, if it escalates in a time-critical manner, nobody's going to come after you in the end and say, well, did you take the time to identify yourself or did you not?
No, they won't.
I think there's also the important dimension of whether you were intentionally not wearing your uniform in order to invite the confidence. Obviously, so in your scenario,
That's the whole point.
Exactly. Can I come in? Can I?
I don't think that the point is to gain the confidence of the other. The point is to prevent them from penetrate.
Being able to access them.
That's not one word.
But I don't. Missing a word.
Penetrate, yeah.
Yeah.
Infiltrate.
So that's a pretty tight rope.
Yeah, but I'm not trying to gain. The thing is, gaining the confidence is, at least within treachery and perfidy, is meant to betray that confidence. I'm not trying to gain that confidence in order to betray that confidence. I'm gaining that confidence in order to move forward.
Can I make a couple of points? One is in relation to at what point must you be visible. And I actually think it's far more individualized than what you suggest. I think it's got to relate to the person's whose confidence you're trying to invite. It's once they can see you.
Then you're doing the hype.
Well, I'm saying there's no point saying you've got to start. I don't know, maybe I'm looking at it in a far more individualized way because you're saying it's about accessing, it's about infiltrating. Well, I've kind of thought it was much more about, but maybe because you're thinking of, you're thinking of your occupation scenario. I need to be able to get there. Well, I'm thinking of other situations where there is no question you're already there, but in order to get sufficiently close to wounding or capturing me. So maybe that's where I draw a distinction. With regard to the whole interplay between Additional Protocol 1, the Hague Regulations, and the ICC statute, obviously there's a reference to the narrower scope of intentions in the crime, but it's completely possible to have a narrower crime than the prohibition. So I don't think that leads us anywhere, unless there was a discussion that they intentionally only covered that because they thought only that was customary.
It's not only that there was no discussion at the Additional Protocol 1 negotiations, there was there was no discussion at the Rome Statute negotiations, but why going back to treachery?
Yeah, so, and I don't know enough whether they were just repeating the Hague regulation crimes at that point and didn't think that it was broader in AP1. But I have to say what troubled me most is the conversation that we just had here about situation of occupation, where essentially it is members of the armed forces doing law enforcement. And that really troubled me, both how you said the court changed its assessment of whether a particular operation was law enforcement or combat just because of the intensity. That troubles me. I think there should be a range of activities that are law enforcement and remain law enforcement, even if you then need to use force. And then assuming we're not talking about, assuming we're not talking about Israel, assuming we're talking about a state that has ratified Additional Protocol 1 and therefore capturing is covered, yes, then I find it very difficult to to distinguish the situations where you would be capturing, so detaining under law enforcement, and those which you would be detaining under IHL. So, and I'd be intrigued to know what those could be. Law enforcement is when you prevent a crime, and IHL related would be when you detain them for imperative reasons of security. Question.
Okay. First of all, about the jurisprudence and law enforcement, right? I think I agree that law enforcement situation should be law enforcement situation, and it goes more than that. There is some threat situation that police is trying to deal with. Police is not working in a risk-free scenario, and I agree that jurisprudence that says that goes too easily from law enforcement to combat activity is wrong. But still, this is the current jurisprudence, and it goes again and again and again in relevant cases where the court is agreeing too easily with the state that this was a combat activity situation. I can criticize it more than I can defend that point of view too much. And other than that, as regard to addition protocol 1 member state doing capturing, then the law enforcement situation becomes much more complicated indeed, because you do have to identify, and I think it's not only what the purpose, but it's also against whom. Because the law IHL operation usually would be conducted against civilian taking direct participation in those activities. And if we are doing this IHL, otherwise we're not allowed to capture the person.
You can detain them for imperative reasons of security.
But not while resulting to perfect.
Well, that's what I'm saying, but I'm saying, where would you draw it?
Where we draw the
So fine, yeah, you wouldn't be able to resort
it's
to
still a
perfect.
case-by-case analysis. Would you take into account the situation, the threat that imposed, the expected resilience, not resilience, resistance from that person, the weapons that they hold, the entire framework, how easy it is to come in and come out. There are a lot of factors that you have to analyze in order to determine whether or not the situation is law enforcement or combat activity.
And are there criteria? Has the court handed down criteria?
Yes, there is in the Uda case criteria presented by the court. Again, it is more for the tort analysis. However, in the policy paper, I do relate to the list of criteria, and I do find them mostly relevant to determining this situation just as well.
Can I ask a question which is partly related?
I get this, Sophia?
Using an army ambulance
Yes.
in order to go and arrest a person.
This is the
This is a good idea. A good idea. So they're arrested. Now, it's at the time where it's an ongoing fight. How would you define that? Is that law enforcement, or is it part of the fighting? When was it legal to use an ambulance?
Well, first of all, since the exploration to detention, even if you consider that a combat action under my legal analysis, it would still remain not a problem.
It will still remain?
Not a problem of perfectly in treachery, because you're in to detain the person, not to kill or wound. The use of the ambulance is pretty much the same notion as I said at the beginning about going into the hospital to detain that with the person in November 2015. The framework remains the same. The question you're saying, because of the fact that we're within an ongoing armed conflict, would you still be able to conduct law enforcement operations? I think that if you're within high intensity conflict and your operation is within that framework, I think it's very hard to argue this is law enforcement. I think it would be extremely hard to argue law enforcement in this kind of example.
So it's, what would you argue? It's not perfectly.
I said the operation was for detention. So it's perfectly
you're endangering in future ambulances. That's your whole argument against it. That you're breaking the trust. That you say people shouldn't fire on ambulances.
And you're trying to
use
stop-
ambulances for these kind of reasons, you're endangering ambulances.
Yes, in a way, yes. But you can say about the entire use of undercover units, the entire use of restoring by the IDF in the West Bank is endangering the civilian population, every part of it. But the law doesn't prohibit for the detention. The law doesn't prohibit losers of war. The law doesn't prohibit any losers of war.
Here's the results from the web.
But what do you do? That's the question I asked you. You didn't really answer that. What do you do if the use of that does endanger the civilian population? So then, it may not as such be legal, but if it is endangering the civilian population, it will become illegal.
Under what provision or specific
Well, if we say
provision?
that, first of all, if we say that human rights law also applies in armed conflict, number one, under human rights law, Article 6 of the International Covenant. But otherwise, you've got to take precautions to protect the civilian population, and you're not doing so.
You could take you could take the complete other position that says that the mere use of undercover unit is also meant to minimize the damage to the civilian population. Because if I'm not gonna come undercover, I'm gonna have to bring the entire brigade into, and the amount of civilian casualties is gonna increase. On the other hand, so in the balance with regard to human rights law applicable, I'm not sure.
That's an empirical question. Okay. Assume that I can show you that it's endangering the civilian population. I can show you that. There's enough evidence to show.
It is endangering.
It is. It's absolutely endangering the civilian population.
More than
Yes.
I have to.
Well, it's always counterfactual. It's very difficult to say it's more than, because you could only do it if you're in the same situation you have the army.
Yeah.
But we do know that it's highly problematical from that. A lot of people have been killed in those situations. We know.
But I'm not sure that more people were killed
Well,
in
but
this kind of
that's not,
situation than the
yeah, but I don't
full
know that you have to prove that.
But if we try to apply international human rights law here, I think there are a problem with extraterritoriality. Because the first thing you said when you started your presentation was that these operations take place outside the borders,
No, occupied territories.
and Israel doesn't accept that.
Yeah, but we do.
Doesn't accept.
And Israel actually accepts most of
The court accepts it. The executive doesn't, but the court applies human rights law.
Can I ask, but what is the responsibility of Israel if the combatants are killed? Does human rights law have anything to do there, or
in what sense?
if these people that are sent to do the conduct the undercover operations, let's say they're all killed?
Isn't that your PhD?
You're talking about the right to life of combatants?
Yes.
You have 3 years available? 2.5.
What kind of legal regime law applies? Will it be which I know nothing about? That's why I don't understand.
I'm not sure I understand. What is the obligation towards Israel if all the undercover unit is being killed?
That Israel have an obligation to protect the right to life of the combatants when they send them to do these operations.
I believe that they do. I'm not sure that this is a common understanding of applicability of right to life to combatants. However, even if we look at EU and UK jurisprudence, we see that the minimal requirement from the state is to provide them with proper training and proper equipment before deployment of the forces in such circumstances. So you can send any soldiers undercover. You have to send a proper prepared unit for that. And in my view, if the risk-benefit analysis shows that the risk is greater than the value of the operation, you're not allowed to send them.
Would the answer be the same? Would the answer be the same if Israel sends an undercover unit in anywhere around the world, like they send in Entebbe to extract the hostages there,
Like in
Entebbe in Uganda to extract? So does it make any difference that it's essentially within the territories or whether it's outside Israel?
which part of the analysis?
I mean, when the responsibility of Israel changes in the way they have to protect the right to life of combatants if they're far away from Israel.
I don't think that would change much. I think that you still would have to send a properly trained unit at least, and to analyze the situation and see if the risk to the unit is higher than the value of the Entebbe situation. Release the hostages. If the risk is too high, then you can't use that method of operation, although if at that time your policy is that you don't negotiate at that time, that you don't negotiate with the kidnappers, with terrorists, then there is also a price of not sending them, which is has great severity for you at the time. Years later will change a lot, but at the time it also has a value to the considerations of the benefit of sending the unit.
Can I ask one more question, which might be a bit silly, but it might be because I understand not a lot by it. So. What is the legal basis of these operations? So these operations, I mean, you discussed the nature, whether it's law enforcement, whether it's military operations, but what's the legal basis?
Either we are within international maritime law, within law enforcement, which is based on international human rights, so international maritime law or international human rights. You're allowed to conduct operations under IHL. If you're in occupied territories, you also have the obligation to do law enforcement, which is maintain the law and order in place, and therefore you're allowed to detain. If you are under IHL, you have the right, not necessarily the obligation, but you have the right to operate against security threat, either a person taking direct economic hostilities or person who has some risk that you are allowed to operate against. You're allowed to target, to kill those who are civilians taking direct economic hostilities. However, you're not allowed to do it, as I argue, by resorting to treachery or perfidy. You do allow to detain them and hold them if they are under risk, other than IHL, which allows you to put them even under administrative detention, or just to hold them and put them in trial. Any questions, comments, requests?
Thank you.
Thank you.